Rule of Law program, and I'm here also on behalf of David Shirk, who has most interesting or most important things to concern about at this moment since he just had his second child yesterday. So 2012 marks halfway of the reform of the judicial system in Mexico, that started in 2008 and is supposed to be fully implemented at the national level in 2016. At this point, we have about 56% of the implementation process, but this process is very uneven, as we'll see in the presentations of our panelists this morning. We're going to see how some states has taken the lead and some others have remained and not do much advance or even not anything to implement their systems. So I'm delighted to be in the table with, I believe, the leading experts of this topic, Mr. Guillermo Cepeda Lecuona, who is I think the most influencing and important expert of this topic in Mexico, as a professor of the Instituto Tecnológico Estudios Superiores de Occidente, and currently working with the Justice Initiative at United States Agency for International Development and MSI. Also Matt Ingram, professor at the State University of New York in Albany, and a former fellow at the Kellogg Institute at Notre Dame, and also as a postdoc fellow in the University of California, San Diego. And also Hugo Concha, who has been a professor in the National Autonomous University of Mexico, UNAM, and other universities such as ITAM, and currently is the chief of staff at the Secretaría Técnica de Implementación de la Reforma de Justicia, CETEC. So with no further ado, I'll leave the floor to Guillermo Cepeda to talk about this report. Very interesting report. Please.
Muy buenos días, agradezco mucho la invitación del Woodrow Wilson Center de la Universidad de San Diego, del Instituto de Estudios Transfronterizos, para
San Diego and Cross-Border Institute, and to you for your interest in this absolutely essential issue, which is strengthening the rule of law, and with regard to one of the most important human rights, which is the right to physical integrity and due process, and also this rule of law is also very linked to quality of life, and this must be addressed in dealing with this issue. And very important for Mexico, it's just such a challenging thing as the reform of the criminal justice system, and there's inertia for 6 or 7 decades. There's been mixed results with the reform, but it has this inquisitorial tradition, and there's a change and a transition. It's not only with the norms, but also there's a legal culture in place, but it also has to be management, investment in human capital. There's a lot of challenges in this reform. It's a huge challenge with regards in view of the complexity of the criminal justice, and people with experience have to be helped with regard to this change, and there has to be a documenting of the resistance to best practices. This is one of the challenges, and also, and CEJA is represented here among the experts, and they've created more than 16 countries in our hemisphere have been studied by CEJA, and they've documented these experiences, so it was absolutely fundamental and absolutely determinant as was said, to generate information and statistics, to be able to follow up and monitor closely and stress what's been doing properly and conduct the appropriate adjustments in a country like a federal country like Mexico, because there's 33 different reforms that have to be done in 32 states and one federal district, and so therefore it's very important to look at the lessons learned from different areas that have of the world that have engaged in this process as well. And so I'm going to sort of sum up the general report that we've issued. What's very important is that we're researchers that have worked on this project. We have 5 state reforms in the states that began with Chihuahua, Oaxaca, Zacatecas, state of Mexico, and Morelos, other states. They are very high quality studies which they involve, and this will be mentioned by my colleague from CEJA. This allowed us to look at the rules and regulations and laws of the states. There's very particularities. There's each state has their own characteristics. They have their own set body of law. And what we did was is that there was a guideline for follow-up. The 11 members of CEJA and a few and 3 SETEC colleagues, we tried to follow guidelines, unified guidelines, to have indicators for the 5 states and to be able to compare them in the final report, which is what I have the honor right now I had the honor of putting together, of writing. After looking at the body of law, so they attended hearings to verify the quality of what was being done, whether the infrastructure was adequate, if there's access to justice, and whether there was mediation and privacy for the parties in mediation processes, whether the defense hearing and the hearings is skilled at cross-examining, whether the judge is actually monitoring the proceedings, or whether there is everybody's keeping to the rules. All these very qualitative data we found, we looked at in these state systems, and over the next months we're going to post them on CEJA's website, and the general report is already up, and Chihuahua and Oaxaca is already ready. The other all of these 5 studies are undergoing editing to be able to be posted on the website, and then there is interviewing of the officials in the state systems, and so the very highly qualitative based report, and there will be statistics to be able to compare, and then to generate best practice, and also to be able to comment what areas there should be intervention and improvements on urgently. That's the purpose of this. And we've commented the purpose is, as we said, is to follow up and monitor and track, have a baseline, and to document best practices, and also to detect what's the most important is lessons learned and what opportunities there are. And we've already mentioned that this is about looking at the bodies of laws and rules and procedures and codes, and we look for statistical information, the indicators that we designed to be able to compare it. In some states we got what we needed very easily. In others we had to use the transparency laws to be able to get this. Even though they had the best authorities had the best intentions, you see, we've learned that they just don't generate the information, and so when you can't measure, you can't improve. That's the approach of CEJA is to emphasize practices. If practices are changes, that's good indications that they're changing for the good. The indicators, we brought them in line with the purposes of the reform. We did a qualitative study of due process to measure the adversarial system and good public defenders' efforts. We wanted to look at it, and we documented the defense. Everything's qualitative. The qualitative assessments we're trying to turn into objective indicators, and we observed the hearings and we interviewed officials. With regard to the budget, this is also addressed in our study. There's very disparate information. Chihuahua is the only state of the 5 that we study that separates out how much is for the reform, how much of the budget is allocated. But $300 million has been earmarked for or allocated over the 4 years of the process, since the process began. Others in Oaxaca, it was said that judiciary, 30 million pesos was used, which is about 2.8 million per region. And so there's this. In the judiciary in Oaxaca, they have this investment that they've made, It's very, it's lower than compared to other states, their investment. However, these are the this is the data we have on budgets and the Office of the Public Prosecutor. We look at the practices and the victims, how victims are tended to, and we're gonna, because of constraints of time, we're just gonna deal right now with the most fundamental aspects of this. So we're looking at the good news. First, we looked at the good news, but we're working on areas of opportunity. One of the good pieces of good news, news items, is what we call inmediación a Mexico. That means that the judge will actually be present not only in criminal matters, but in others. The judges were never present at hearings. It was the public defender usually was not present either, and at the end, but would just come at the end of the day to sign the actually, and so neither had been there, and so this would leave people defenseless. And this was widespread in the traditional criminal proceeding system. I'm going to give you an example of one of my students who's from Guadalajara, who worked at the court, the criminal court. He said, "Professor," he said, "you talk a lot about, and you recommend that presumed guilty, and don't be surprised about that. That's not real. That's just been set up." And I said, "Yes, it's real. I know that it is." He says, "No." He said, "The person who made that movie doesn't know how it works in Mexico criminal." He saw that did you notice the judge has the robe on, and that happens. I've worked there, and there's never what it is. The clerk is in there, and the clerk is the only person there, so 170,000 are denied justice is what happened, and they don't have the chance to go before the judge, and the system is what it is. That's what he said. Also, there's been a lot of progress with regard to prevention in the 5 states, but also there's a Baja California study that's been conducted, and there's a willingness of other local authorities to provide us information. And there's a validation seminar about the Durango report. We're checking out all the to make sure that the indicators can be used. And the study is basically about the 5, but in the 7 different ones, these additional ones, except for Chihuahua, there's been a drop in prevention, and this has to do with several variables. And so there were small-scale robberies have been emphasized a lot. And then when it's 3 people involved, they call it, there's different aggravating factors that are, and to define a robbery. And so a lot of times, because a lot of times people are released when it comes time for sentencing them, and they'll get off. So it's like there's a huge amounts of money that are invested to have, and so therefore the fines are set, and there's a lot of misdemeanors that people are sentenced for. So it says that and everywhere you have to stop the criminal proceeding from going forward to try to save and avoid prison is what we're trying to say. It's the traditional system. It was the other way around. They always tried, and so 25,000 people therefore have avoided preventive detention. And Baja California is a paradigmatic case. Before it was the most saturated prison system I work on. It's 190, this high, over 100%, way over 100%. People were jailed, and with 2 years of reform, it's way below the means, which is 124 of it's about 113. It used to be like 170 something, and the security indicators are not at risk, and so people can be released on bail with a minimum risk of the violence rate going up or crime rate going up. This has to do with misdemeanors, which in the past they would have to be jailed, but now it's changed. This is information is how many 100,000 population, how many convictions there are. There's also been, in the general report that's on Ceja's website, it shows that in Chihuahua it went down from 43 to 32% of prison with this movie called Despertares. And now it's gone back up for 48% against because of a legislative sabotage, which to go back to the to crimes that people can't be jailed for. And so that going back to the Office of the Attorney General, there's been a doubling of the cases. Only one of every 5 investigations are completed in the states with reform. In states like Chihuahua, with the one that was with the ones without reform. In Oaxaca, for example, it's doubled. 42% of the cases are disposed of. And so, but we're very far from the goals that we set out for ourselves. But it's a good indicator. In Baja California, it's 49%. And they've also set a very ambitious of 75% of cases. It's 49 right now, but it's very respectable compared to the rest of the country. Zacatecas is 34% of the capacity of response. And the state of Mexico and Morelos are lagging behind. Morelos almost doesn't use these alternative sentencing. It has 13.5% of cases that are disposed of. And an area of opportunity that we're going to address at the end of is that most of the states depend a lot still. The states with a reform of the 5 states, they have opted for these alternative sentences. As I said, the heart of impunity, but with the adversarial system, we're trying to prosecute more cases, of course, on the one hand, but it's bad that it depends so much on alternative sentencing. But when people are caught in flagrant committing in flagrante, they have to be held in jail. They're sparring. They'd always favor the prosecutor's office taking the money and not allowing the Office of the Public Defender have any money. But now we've seen with our own eyes, we've established that there's good procedures and there's good skills among the defense attorneys in their cross-examining. As Ernesto said, 90% in Baja California of the cases are taken by a public defender, and most defendants prefer a public defender. And we also, in our report, in several hearings in Chihuahua and Oaxaca particularly, they just suspended the hearings and scolded the private defense attorney for not being skilled enough and called in a public defender so that 2 or 3 days later the case continued, and so not leave the defendant defenseless for an incompetent attorney. And so there's been more. In the best practice section, we've also mentioned best practices. Public defenders in the state of Nuevo León is independent. It has its own operationally, technically, and with its own budget, and it's the only one with expert witnesses for itself. This is the only one because in other places they have to sort of beg for expert testimonies or expert witnesses, but not in Nuevo León state. They have certain mechanisms and access to private attorneys as well. And this is a good step to be able to fulfill and make this a truly adversarial system, which is what we've set out to do with the reform and better rights and better victim assistance. We now see after our survey that there's new rights for the victims, and they can challenge decisions that are not appropriate. Those decisions made by the prosecutor's office, and they demand evidence, and there can be private actions filed. 70% of the oral trials, there was always the victim was always present as a party. That recommendations have been put forth, can be put forth by them, but there's more presence of the victims. Some of there cannot be an alternative sentence if they do not provide reparation or redress the harm, and less than 3% of the cases have challenges. Many times there can be a challenge. There can be a challenge to alternative sentences, but it's challenged very little. One of the best things is that doesn't have to be done. It's good that the victim doesn't have to be bringing forward the case, and the system itself does this. That's what the important thing is. Now there's been an increase of access to effective and timely justice through alternative justice mechanisms, and we have the cases there's cases that are more swiftly disposed of. And there was recently a survey, and we are waiting for this because there are already focus groups about the users, with the users of the systems to see how satisfied they were, and to dispel one of the myths from the traditional system, that there could be double victimization of people when they use these non-punitive alternative sentences. But it's a good thing that the perception is positive among users of this new mechanism. In SETEC's survey, we hope we get these results soon. Also, the proceedings are lasting less, trials are less, and this has an effect, a bearing on costs. There's a cost study, a very interesting one. It was a cost-benefit analysis showed that the new criminal justice system is feasible and viable. It uses a lot of, in 2 of every 3 conviction are for misdemeanors, so we have to look closely at this. And robbery is what's prosecuted the most, and transit-related or traffic-related things. That's what's prosecuted the most. And there's there's other ways to handle these cases. And Dina Negrete suggested this, a more focused policy. And there's a broad range of violence and infringements of the rights of victims, and each one of these 7 or 8 categories of crimes requires a prevention policy and a specific care policy. And there has to be flexibility to be more prudent with the use of our resources. And we have to be also prudent with the criminal justice system, which it's very disruptive to the country. So this graph shows a comparison between the percentages of convictions in local trials in Mexico, state trials. There some of the states without reform, and some of the others, 64% of the convictions are for 3 years. And even 30% are for less than a year of the convictions, or less than a year. So and you can pay a fine of 600 pesos a lot of times instead. And a lot of these people were in preventive detention, those who pay these fines. Unfortunately, in Mexico, there's a catalog of cases that you can be released on jail. There's a lot of documentation of status, and for example, somebody just stealing a skateboard. And the idea is that he was in the garden and not on the sidewalk, and therefore it was burglary because it wasn't on the. And so there was 8 months. The sentence was for 8 months just because of this, because it was in a garden and not in the yard of the person instead of on the sidewalk.
Son los que distraen el 35%, y de 1 a 3 años 27%. Son los delitos que están que tienen, se ha comentado aquí, pocos delitos se reportan, y con eso basta para colapsar al sistema de justicia y hacerlo intensamente demandante de uso de recursos. Hemos duplicado en 8 años el número de personas en prisión sin que los mexicanos nos sentamos 2 veces más seguros.
We have doubled sentences, but Mexicans are not twice as safe. We spend $3 million a day for keeping people in prison, half of them pretrial imprisonment, and in red it shows that many of these cases they can be channeled to alternative mechanisms. And in terms of sentences, we see a movement toward more severe sentencing. One fundamental variable that's been mentioned here has been to pursue intentional homicides. How can they be punished and clarified in Mexico? For those states that have the reform, it's a challenge, but in general one sees this movement. Cases involving lesser amounts or without violence, particularly unintentional, are, well, now 20% are less than 1 year. But it is a considerable improvement with respect to the prior system. This is what you're going to like most of my presentation, not because it's the most interesting part, because it's the last part. And we must also document. There are optimistic figures, but we need to document the red foci in some states we have this problem. We need to improve investigative capacity, as has been said here. This is fundamental. The amounts to judges have fallen sharply, except in Chihuahua and one other. But otherwise, in Zacatecas, for example, 2.5% of the cases that enter the system reach the judge, of those already reported. 3.5% in Morelos. In Oaxaca, well, the rate is still 6 or 7%, but conciliation happens before the judges, and backlogs were cleared up. As Laura said, we've cleared up the backlog of minor cases so that the prosecutorial offices can deal with the major cases. This doesn't happen automatically, as she says. We need to develop these capabilities. All of the attorney generals of the states that have the reform are investing resources and working on this part, and interventions are being designed to improve these arrangements, and we're going to talk about some best practices that have been documented. In Baja California, they have a unit for attending to crimes where no one's been arrested. Generally, the prosecutorial officer says, well, we have 5 persons who have been arrested, and we have 48 hours to determine whether we move these cases forward or not. We're distracted by these cases. So there's a unit that is solely for clarifying cases where no one has been arrested. 99% of the cases that reach a judge, well, these were in flagrante delicto. And even in the traditional system, it's 72 hours later. In these cases, little by little, there's progress, say 15%, but we know that the frontier must be beyond that. More cases need to be investigated. But these kinds of practices, improving investigative protocols in Chihuahua, it's striking that there's 90% effectiveness in kidnapping, and 8 cubicles down, there's the Homicide Bureau, which is 8% effectiveness. So these protocols on how to combat these crimes, how to train personnel, and in Chihuahua, in addition to the human capital and the management protocols, there's the whole question of, well, of 480 homicides in a year, they went to 3,800 in just a few years, overwhelming their capacity. And more than 40 staff of the Office of the Prosecutor have been assassinated, so there's a very serious issue of protecting them. The need for civil service career, well, we were saying this is there needs to be an administrative model, but also human capital, and we don't work well with, and the reform itself undercut the labor stability of persons working in the Office of Public Prosecutors. It can be determined that somebody who was removed, well, if it's determined that somebody who was removed from the police, that it wasn't justified, they cannot be reinstated. But also, upstanding officers can be impacted. So it's a fundamental that we have civil service career civil service. And we have this problem of labor instability. Of the 5 states that reported in 2010, well, it was clear that when we went into a seminar to validate the diagnostics, we saw there were other state attorney general's offices there. Some had been receiving training for 3 years for litigation. In Oaxaca, we found that under the traditional system, some investigate and others litigate, and we thought this was an anomaly. And the Attorney General said we have 8 prosecutors with oral trial capabilities, and 5 took off. They went to other cases that were implementing the reform, so we're understaffed, and the ones that were left went to the regions where the reform was going forward to litigate, and the others investigate. So there are also shifts, 24 to 48 hours. People leave the shift, or they may have to remain for another 6 hours for somebody who they arrested. And in the first years, 20-some staff resigned from the prosecutor's office. So there's the whole issue of working conditions and long-term incentives. So this is a fundamental challenge that the reform faces. Need to monitor judicial conditions. Well, there's the question of legitimacy of alternative approaches. There are good rates, 80, 85, 90% in the states. The lowest is 79% in Chihuahua. The agreements on reparation are being carried out. We need to make sure that this figure not drop below 90%. And also, you cannot say completed until the last payment is made, especially when several payments are promised or committed to. But the effectiveness should not drop below 90%, or judicial measures. If there's a stay order, for example, to not approach the victims where the victim lives or works, well, the victim needs to have a phone to be able to report if this does happen. It's fundamental to defend and support the alternative systems, but there must be a tracking system. There's an office in Chihuahua that has 130 staff that follows up on these agreements on reparation and status of judicial measures. There are serious reforms. We were talking about Chihuahua. There was the question of persons who could be released, but they're not. And there's also a Trojan horse. One can look at the investigation or get into it and then raise the question of grounds for invalidity of it. Nonetheless, a matter may move on to oral trial, but with an empty content. I should also mention the relationship with the amparo remedy is fundamental. Judges who review state cases continue to have ideas from the traditional system. They talk about weighted evidence, the corpus delictus. They are saying that one must learn of the investigation in the hearing, which has led to undesirable practices, for example. Well, as we say, to protect oneself, one reads the entire file in the hearing. So you need to get a scholarship to go to the hearing. They're going to read this, the entire file, investigative file. So anomalies such as this need to be addressed, and one must coordinate so as to not throw the criminal justice process off track. And the police is fundamental. 9 of 10 detentions is by uniformed police. They need to be trained in arrests in the new system. In Baja California, there's been very good training of the police. Some cases have been resolved because the area of the crime was clearly delimited, because information was taken from the eyewitnesses or relevant witnesses. And this is fundamental. In other states, well, when we call them to seminars, they say, on criminal justice, they say, well, why us? We're the police. What does the police have to do with this? And the next step that we're taking in this monitoring program is to learn from these experiences. On the 27th, we presented the report in Mexico City, and we held seminars for 2 days. And we're drawing up the ideal alignment with the protocols of investigation, such as they have in Chihuahua, the injunctive measures unit in Morelos and Baja California. We're going to have independent public defenders with their own experts in Nuevo León. We're going to have the communication system. I've been told that I have only 40 minutes left. And best practices, so that at each link in the system, there's certain things to be presumed and others to be avoided. So in each segment, there's a monitoring unit, a criminal justice policy unit, to make sure that the policy points. So if we say we're not going to have any abbreviated procedure, we're going to have oral trial, well, one needs to see that if it's an abbreviated procedure, it's because with a negotiation that would be adequate for society, such as they already have in Chihuahua. Well, we've documented this ideal alignment of the new system, lessons learned that we need to build on for those coming behind us. When we see states that are in the planning, we offer them these top 10 practices so that in their planning, these measures can be accounted for and budgeted so that the documented best practices can be useful for making progress. Thank you for your attention and patience. Muchas gracias, Guillermo, por esta presentación tan interesante. Ahora voy a dar la palabra a Matt Ingram. Es uno de los principales expertos sobre reforma judicial y el sistema judicial en México de este lado de la frontera, y él nos va a presentar una perspectiva sumamente interesante por el lado de policivo. Él fue policía, pero también es abogado y tiene un doctorado en ciencias políticas.
He's going to present this research that was commissioned by the Wilson Center and will be included in a policy paper next year. So, Matt, please.
Thank you, Octavio. Is this mic working? Yeah, thank you. Like Laida, I'm more shark than fish and need to move in order to find fresh water, in order to breathe. So I might find myself circulating back among you, hopefully not too far. Thank you to the Woodrow Wilson Center, the Woodrow Wilson and the Mexico Institute here, and to the Transborder Institute, specifically Eric Olson and David Shirk and Octavio Rodriguez. It's really a pleasure to be here. Also, part of what I'm going to present today forms part of a broader paper, more detailed paper, that will be posted on the Wilson website within the next 2 or 3 weeks. So please follow up, and I'd love to hear your feedback. Y por si acaso hay preguntas en español, por favor, soy originalmente de México, de Guadalajara, y podemos conversar o podemos contestar preguntas tanto en inglés como en español, como muchos de mis compañeros aquí. I'm going to try to do 2 things in the next 15 minutes, both zoom in and zoom out, sort of taking Guillermo's presentation as my point of reference. Zoom out to a more macro, maybe meso-macro perspective on what's happening in Mexico with regards to the progress across all 32 states, or 33 reforms, as Guillermo mentioned. The federal reform is one of the necessary reforms. And then a more micro, perhaps, level, zooming in further than the state level, where Guillermo was, to the district level, right? The level of judicial districts in one state, in Chihuahua. So I'm going to zoom out to look at all states. By necessity, that zooming out requires a different level of abstraction, maybe not the kind of rich, textured, fine evidence that Guillermo's project has revealed, but a slightly more abstracted, generalized way of looking at the progress of the reform. But I'll also add one measure that I think is a nice contribution. I wanted to say one very, this is where I'm headed, and I just wanted to spend a quick minute or 2 at the beginning taking an overview of the reform content, because nobody sort of touched on this, looked at the full spectrum of changes required by this reform and just how daunting a task this is. This is truly, as Maximo Langer, comparative law scholar at UCLA, has said, a revolutionary transformation. So it's hard to overstate the scale of the change that this reform requires. So starting with police training, there's all this emphasis on investigatory capacity, but I would add that one of the pending reforms is police autonomy. In the United States, we tend to think of police, detectives, investigators as having a great degree of independence, autonomy from the prosecutors. That is explicitly not the case in Mexico, even after the reform. The reform specifically says that police shall remain subordinate to the prosecutors. There are some exceptions at the federal level with this, but by and large, police including the most well-trained investigators, remained dependent, subordinate to prosecutors. As Laida and others have mentioned, and Guillermo has mentioned, there's a wide range of efforts to improve, strengthen, bolster victim and defendant rights, right? Both sides of this equation. An emphasis on preventive or pretrial detention, as Guillermo has mentioned as well. One of the major changes is in allowing for prosecutorial discretion, right? What's comparatively referred to as the principle of opportunity, contrasted with the principle of legality. There's all these alternative exits. So as you're heading down the highway of the criminal process, right? You used to have to stay on the thruway or the turnpike, right, all the way to the end, and now you can get off at certain exits, right? Acuerdos reparatorios, plea bargainings, all these different exits, right? Then there's all these alternative sentencing options that were previously underutilized or unknown, right? Diversion, probation, everything that we understand here in the United States as alternative sentencing arrangements. Private prosecution, something that's unheard of in the United States, but our neighbors to the north in Canada utilize, and a lot of countries comparatively utilize private prosecutions, right? So this is a mechanism of accountability that can also help to control corruption or impunity within the Attorney General's offices. There's a new figure of a due process judge at the front end of the criminal procedure, right? Sort of our first hearings, our first court hearings, where the judge is supposed to review, right? All the due process obligations were met in order to proceed, right? Including the gathering of evidence. So a whole new attention to exclusionary rules, fruits of the poisonous tree, these kinds of doctrines that are commonplace on this side of the border and in other countries. Then as Laida mentioned, right, this is a much bigger picture, right? We're just getting to oral trials, right? Oral trials are really a small but very visible part of the reform project. And then on the tail end, one of the more interesting pieces of the reform puzzle, right, are these compliance judges, or what some people might refer to as sentencing oversight judges. And the key change here is that supervision of sentencing, right, calculating good time credit, work time credit, whether the sentence has been fulfilled, is transferred from the executive branch to the judicial branch, right? Literally creating new judges, new judgeships to oversee the completion, right, the compliance with sentencing. And for comparative legal scholars, comparative judicial politics scholars, policy analysts, this is a really interesting piece of the puzzle, right? Enforcement, compliance. Robert Wernick has emphasized this, right? That these judges might be the source of new data, new really interesting data about how our judgments really being complied with, right? And these compliance judges supervise also the alternative exits, right? All the acuerdos reparatorios and these procedimiento abreviado, all of these different things. And then we have the piece of organized crime, right? Which sort of we've referred to already as a sort of state of exception, but again, just a small piece of a much bigger puzzle. And then all states and the federal level of government are supposed to implement this by 2016. A Sisyphean task, to put it succinctly. So how might we go about seeing how different states are progressing along this reform process, right? Which states are ahead in this reform process? Which states are going to meet the 2016 deadline? Which states are clearly not going to, right? So where might we place states on this? And my approach to this is that two key pieces of legislation emerge from this big reform project that we just looked at, right? The key piece of legislation is a new code of criminal procedure, right? And the different states refer to this by different names: Código Procesal Penal, Código de Procedimientos Penales. But this is the key piece of legislation that's going to really establish the rules for the oral trials, for how evidence is entered, for the alternative exits, for the due process judges. All of these different pieces that I just summarized are going to be in here, right? The compliance judges are going to be in the second piece of legislation, right? Which different states refer to as Ley de Ejecución de Sanciones, Ley de Ejecución de Penas, And this new judge is either a juez ejecutor, or a juez de ejecución de penas, or a juez de ejecución de sanciones, or de sentencias. But the point being that these are the two, there's a wide range of laws and implementing legislation that Eric referred to earlier, or the term that he used earlier. But these are the two, I would say, key pieces of legislation, and others may disagree. So how might we go about measuring this progress? We want to look at both the formal approval of these laws, but then the practical operational implementation. Right? So the formal approval, I look at whether a bill is initiated in the legislature at the state level, when it's approved, and whether it's a full reform or not. And by full reform, I mean not Nuevo León. Right? Nuevo León approved a reform, but it applies only to first to a small set of crimes, then to a slightly expanded set of crimes. It still, to this day, does not apply to all crimes across the board. So you have judges wearing two hats, right, within the same criminal justice system, without sort of an expiration date for the old system. And some other states are following that model. Right? Guerrero is thinking about following that model. I believe Sonora is also thinking about following this model of kind of a mixed implementation. Operationally, we want to know that it's legally effective, so formally, has it been implemented? And then other scholars of comparative politics look at the age of the law as a signal of its institutionalization. So how deeply rooted is it? A very simple measure of that is sort of chronological age. We want to look at geographic coverage. In many states, this law is not passed across the board throughout the entire state at one time. It begins in one judicial district, spreads to another, and eventually is supposed to, as it's done in Chihuahua, Estado de Mexico, and Morelos, cover the whole state. Right? And then this one measure that I'm adding to this is new cases entering the new reform system as a percentage of all criminal cases, all new criminal cases. And this is an interesting measure, I would say, because the traditional system survives even after the reform, right? New cases might start entering one judicial district, but the law hasn't been implemented in another judicial district, right? Or in Nuevo León, it's applying to one set of crimes, but not to another. And in Chile, even though we saw the reform completely implemented by 2005 in the entire country, cases were entering under the traditional system through at least 2010. So we're looking at least a 5-year lag period. And this is the poster child of the reform in Latin America, right? As Laida mentioned and other people have mentioned. And even there, in this sort of ideal unitary system with lots of resources, a strong police with investigatory capacity, cases are entering the old system even 5 years after the reform is fully implemented throughout the entire country. Right? So we should not be surprised to see cases entering the traditional system long after implementation. So what does this look like across the countries? I looked at a lot of documents to sort of get this information, mostly the annual court reports, many of the same sources that Guillermo and his team of 11 researchers used. Annual court reports, state legislation, specifically this Code of Criminal Procedure, and the sentencing law. So what does this look like when we start to look at this across the country? This is a map of Mexico as you see reform being approved, right? Just reform being approved. You've got a bill and it's being approved. We would add Chiapas here in May of this year. I just made a mistake with this last map. But in May of this year, Chiapas approved its reform. You can see a huge jump, an almost 100% increase from 2011 to 2012. 11 new states approved reforms just in this last year. So there's a huge jump here. We can see this differently, right? Different shades. Darker shades indicate sort of older approval dates. So you see Nuevo León, which other people have highlighted as a kind of front runner of the reform. Chihuahua, Oaxaca, Estado de Mexico, and Morelos. And then other states in lighter colors. In some states, again, sorry, Chiapas should be in blue, but some states still with zero reform, right? With 4 years left. We can see this in another way. As I said, 22 states have approved the new code. So 56% of the way through the time period, 69% of states have at least approved a code. And so this is good news. This is a small piece of good news in what has otherwise been a rather bleak period for the last couple of years. But I would say the bleakest period was in this phase here where the blue line sort of dropped below the timeline, 2010, 2011. And this is where there was a lot of concern. Will Mexico be able to approve this new system by 2016? I think there's some cause for optimism, at least just by this measure alone, right? Now this is now where the new code has been implemented. So we see it's been done in 12 states. Again, if I had colored in Chiapas correctly, we'd see 12 states here. Again, the darker colors indicate the older states where it's been in place the longest. And this is what implementation looked like, right? So we're still lagging behind in terms of how far we've progressed temporally and how many codes are actually operationally, practically effective. 56% of the way through, only 38% of states have implemented the new code. We could build more, sort of any variety of reform indices, adding the factors I mentioned earlier, sort of the various measures that I mentioned earlier. And this is what it might be, what it might look like across all states. I'd be happy to sort of come back to this in Q&A later. But this is using Chihuahua as the benchmark, right? And we see Chihuahua here as being sort of, not that it's 100% completion, right? But it is the most advanced state. And I'll come back to Chihuahua in just a second. So compared to Chihuahua, where are other states? So you see this sort of temporal variation here and also spatial cross-state variation. That's just looking at the Code of Criminal Procedure. If we add the new sentencing law, then this is the variation that we see. And this is what it looks like sort of mapped out, right? The states that are most advanced, with Chihuahua being up at 100. I'm just going to take 2 minutes. I'm just going to look at a couple of these states this way to go back to that one variable that I mentioned in terms of cases entering the new system as a percentage of all new criminal cases, right? Not just the ones entering the reformed system. But this is what it looks like in Chihuahua. The blue line are cases entering the traditional system, and you see that's declining over time. The reform takes place in 2006. It's implemented in 2007. It's complete throughout the state by 2008. And you see the cases in red indicating the cases entering the new system, climbing as the traditional cases are declining. The red line indicates what percentage the red bars represent as the total of both bars, if that makes sense. So this gives us a comparative measure of how states are advancing with new cases entering the new system as a comparison with in reference to all new criminal cases, right? Entering both the new and the traditional system. We could go through different states, what they look like in this regard, with regard to this measure. Nuevo León is interesting in one respect in that it has expanded this new criminal procedure to civil and family cases, and it's really very advanced in the family legislation area. Both civil and family, of course, have a much higher volume of litigation than the criminal sector, which is poses a lot of interesting questions, right? And this is what the 12 leading states look like based just on that measure, right? With a percent of cases entering the new system. Chihuahua, this is just the raw percentage, right? Chihuahua is no longer the benchmark. You see Chihuahua quickly approaching 100% of all new criminal cases entering the new reform system. Other states are far behind. Nuevo León is remarkably low, long after the reform, right? This is the oldest reform in the country. And less than 10% of all new criminal cases are actually entering the new reformed system, right? This is why Nuevo León is disappointing to many observers of the reform. I just want to take a quick look inside Chihuahua at the level of the districts. If we aggregate the data by municipality, this is what it looks like over time, right? It expanded from the capital and the city of Chihuahua. Ciudad Juárez is in the north. And the colors indicate the percentage of new cases entering the criminal system that are part of the new reform system, right? As a percentage of all criminal cases. By the end of last year, 2011, most of the state was above 80%, above 80%. And if we look at at all of the districts, this is what all of the districts look like. In the Distrito Judicial de Rayón, 100% of all new criminal cases are entering the new reform system. And it's very close. It's above 90% across most of these districts. It's another reason why Chihuahua is a front runner in this regard, right? By this is as of last year. So I would suspect that at the end of 2012, we don't have the informe, right, to look at the data yet. But by January or February, when I look at this again, I would expect that perhaps with the exception of Ciudad Juárez, which is in the Distrito de Bravos, right, which you see a decline, preoccupying decline in the percentage of cases entering the new system as a percentage of all cases, I would expect that many of these districts will have reached 100%. So I'm going to stop there. I've got a couple of other concluding remarks, and including persistent challenges, namely regarding data availability, its uniformity and evenness, which I think echoes a lot of the concerns of other presenters. But I'll stop there and turn the microphone over to others.
Thanks, Matt. Now we'll have the presentation of Hugo Concha Cantú, which has a very interesting perspective as well from the academic world in UNAM and ITAM, and a very interesting perspective as well as a public servant at some institutions, especially lately as a chief of staff at the executive secretary at the Council of Implementation of Judicial Reform, CETEC. So, yes.
Well, hello to everybody. I will just make my brief introduction in English and then shift to Spanish, because I have this fantasy that if I speak in Spanish, I will be, more able to use my time properly. Well, first of all, thank you very much to the Wilson Center, to the Transborder Institutes, personally to Eric Olson. I don't see him. He must be around here. Thank you, Eric. The original invitation was not sent to me, was sent to the Secretario Técnico del Consejo de Coordinación para la Implementación del Nuevo Sistema de Justicia Penal, long name, Felipe Borrego.
Felipe Borrego is who received the invitation, pero como entenderán ustedes, se encuentra en este
leaving the office, so he was not able to come here, and then the invitation came to me. But I should confess to you that this is, I hope, the closer I want to feel to be like a dead man walking, because I don't know if it's a matter of minutes, days, that I will leave this particular obligation to. Anyway, this is a joke, of course. I'm eager to reincorporate full-time to my academic and consultant activities that I really like. Anyway, this is sort of an official, but with some critical, of course, perspective, presentation. First of all, déjenme hablar de algunos aspectos que no se conocen mucho sobre algunas vicisitudes que ha tenido esta reforma, y me parece importante en una apreciación justa y completa poderlas tener en cuenta. Primero, y eso sí ya se refirió muy bien particularmente a Ana Laura Magaloni, esta reforma tuvo un origen un tanto confuso, por no decir incluso contradictorio, ¿no? Eran dos grandes reformas que venían en sentido prácticamente opuesto y acabaron mezclándose en la conocida hoy reforma en materia de seguridad y justicia, ¿no? Una reforma policíaca, que era la que quería el Ejecutivo Federal, y una reforma de derechos, que era la que quería la sociedad, con muy buen apoyo además de algunos órganos y gobiernos extranjeros, particularmente el norteamericano. También otro elemento que me parece muy importante mencionar, los trágicos eventos que salpicaron a esta reforma en su inicio. Recién nombrado el primer secretario técnico, este señor venía en el avión que cayó en la Ciudad de México junto con el secretario de Gobernación, y eso obviamente no fue el mejor de los inicios. Él era el que traía una idea de hacia dónde había que manejar esta reforma, y por supuesto todo esto implicó un rediseño de la misma. Y sucedió una cosa más también que no es del todo conocido públicamente. Una vez que esta confusa y hasta contradictoria reforma se mezcla, de acuerdo con uno de los transitorios de la propia reforma constitucional, se establecía que se tenía que detallar cómo iban a ser los órganos encargados de la
Whether the
implementación. Se
different bodies,
mencionan en la
agencies that were going to be in charge of it, it was mentioned in the reform itself, but there wasn't a lot of detail. It just said it's setting up these agencies. But 2 months after, in October, 2 months after if it was passed, the federal executive, without consulting the other branches of government, issues a decree to create the Council of Coordination and of the Technical Secretariat. And this issue, really, if it went unnoticed, because the federal executive, without consultation, did two things by not consulting. It disturbed the other branches of government, particularly the federal judiciary, which is part of the coordination council. It's a council of state, which includes all the branches. It is, and nobody thought about doubted this. The three branches of government have to be represented, and the representative of the representatives of the secretariats of public security and civil society and prosecutors and every branch of the courts themselves and have to be represented. So the executive did this way and issued this decree and takes control, absolute control of the speed or pace of the reform, so to speak. An executive branch that wasn't really convinced either of the reform and takes it over and takes the majority of the members of the council, It sounds like gossip, of course, what I'm saying to you, but the fact of the matter is what this did was that the federal judiciary took almost practically a year to accept and to hold the first session of this council. And if it wasn't being installed, nothing was going to happen. Wouldn't move forward. And so there was a new agreement had to be reached between the branches of government. Everybody had to be consulted first to be able to move forward. These are little pieces of information, but they're important to know to get to grasp the concept of it all. And other aspects were also relevant. I always use complexity and it's not well viewed in social science, but I think it's the right word here. There's been a lot of different complexities in implementation of the reform. The first complexity, and I loved Matt's presentation, I really was to coordinate 32 reform processes is complicated, particularly when the body in charge of it is about because of the famous decree, which was not very strong. It didn't have much teeth. It was given a subsecretariat level. It was assigned to it, and it was a subsecretariat within a structure which was a labyrinth and difficult for the Secretary of Interior could even follow. And so it was very unlikely that it was strong enough to establish a mandate or any kind of obligation for all the sectors that were involved. So this coordination is very complex and complicated and had to be linked with, as implementation moved forward, with other actors as well who are very important in the implementation process. It has to be coordinated as well with agencies, foreign governments who have been working on this as well, on this project as well. And then also there were civil society organizations that began to emerge that were very about specific issues, but this was very important for implementation, however. So there was a very complex coordinating effort that was involved in this. In addition to this, there had to be integrality or completeness, so to speak, because within each state or federal entity, as we call them, and there are people here that can ratify this, there's a lot of internecine struggles between internal fights, and so to carry out this implementation, if the local government wasn't firm about this, there was a superior a Secretariat of Public Security, all the different agencies within the states were trying to fighting over what they would be involved with, and so that this completeness or the integrated quality of it all was also caused a lot of. So then I want to give you an advance about something. So what happened was the money started to flow in the form of subsidies, because one of the first requirements from the technical secretariat gave is that there has to be an implementing body within each state. And this obviously helped a lot. They created the implementing bodies, and we still have four national meetings were held with the implementing bodies throughout the country. But I was saying this was after a lot of problems. We finally ironed that out. Political will of the stakeholders or actors involved is fundamental as well. And not only talking about the governors and what happens in other states or federal entities, I'm talking about the political will of the federal authorities. There was an executive branch that approved the reform, and a sweeping reform, and absolutely, and there were even more than 2 reforms that were approved 2 years, but there was no will to push it as far as it could and should go. With regard, in the context of the fight against organized crime, and it seemed that it wasn't a priority of the federal government. The other branches of the government didn't take it to this problem very seriously as well, and it's the federal government that they would say is till there's not a federal procedural code, they can't do anything. They've had some significant training programs. Miguel can attest to that, but that's as far as it went. But with regard to the legislative branch, since October last year, the bill has gone nowhere for the approval of the criminal procedural code. So the issue of political will is also very important. There's another problem that we can also exist, which is a lack of uniformity and standardization. And as a matter of fact, the famous Pact for Mexico that the 3 major political parties signed, I think it was 1978, 79, goes back. And it's about this sort of push forward the discussion to have a single criminal code that applies to all the states. And because there's sort of it turns into a Balkan situation, a Balkanization, so to speak. Where then is the new system? What is it going to be like? There's so many ways to implement it. It can even be masked, and it's still the old one, but just masked as a new one. And so this is a very important issue because some of the states that Matt mentioned are very much affected by this problem. There were 8 states that started the implementation and completed the reform before the national reform was the constitutional reform from 2008. Not all of them. A few states that were well on the way, but some of these states stopped. They couldn't move any further, and others have had to go back and reformulate things based on what the Constitution says. So this is another important issue to mention. And also the content of the reform in and of itself is not that it's so simple to establish this, particularly from a cultural point of view. Matt said it very perfectly, so I can skip that part. In light of this context, and I would add one more complexity based on everything that I've listed. So there's also a crisis of installed capacity throughout the entire country, particularly in federal agencies, to produce systematic information and a culture of producing information and data and statistics and make it available to the public. This is very relevant complexity in this, to be able to conduct follow-up, and monitoring, etc. After saying this, the CETEC did 2 major things. There were 2 lines of action that it followed. Generate products, output, models, prototypes, studies, things of all this publications and everything, all types. Several, we could talk about a lot of them, but my time would go if I talked about each one of the deliverables or outputs or programs. And also place them at the disposal of all of the states. So the planning model, so that the states could adopt it and know exactly what happens. What do they have to do? How much is it going to cost? What is the timeline that they have to fulfill for those that are in? And remember, and part of the complexity, remember that this is an authentically federal-centered reform, and so in 2000, they can either ask for assistance or not. They can decide. It's the implementing national or federal implementing organ is waiting for help to be asked from the states to be able to move forward in this. So the other path forward was the subsidies. Now in 2010, for the first year, 2 years after reform actually started, the federal government decided not only to give it to CETEC money, because they hadn't given money to CETEC, but to provide subsidies so that the federal entities, the states, would be able to implement this project. There were guidelines that were created to approve it all. There was a very complicated methodology or procedure, but this started as of 2010, these subsidies. With the subsidies, everything worked a little bit better with this. It's very important for there to be money so that the states and the actors and stakeholders have an incentive to move forward. From the point of view of the products, the first thing I said, CETEC organized the major topics where there had to be products. Planning, as I mentioned, is one thing. Studies or surveys, and draft codes, federal code, local or state codes, draft state codes. Training also has been a very extensive and complicated issue. It's the second period of the reform, of implementation. A lot of institutions have taken part to be able to make it as complete as possible, of course. With regard to institutional reorganization, it's emphasized a lot. This is absolutely fundamental. The Chileans said the key of it is in management, is what the Chileans said, but the management is the most important, so that the new institutions operate properly. And the very important things were done. There's a new management model that was used for all the institutions, and also with regard to dissemination or education. And this is the central approach of to have commercials and things like that, and linking with other sectors, and evaluation and monitoring is another one. Subsidies, as I said, infrastructure, and there's publications for all of these things, as I said before, and things that were done. The subsidies, with regard to subsidies, the same thing that were given over the 3 years. In 2012, 443 million pesos. It sounds like a lot, but it's very little money to be able to bring this forward throughout the country. This is only for the states. There's more or less, you can see how it's divided up. It's about $34 million is what it's equivalent to. And the total, and for 2010 to 2012, there's a total of 1.2 billion pesos. It's not the only subsidy that's given to the states by the government, but the states, they have to be able. They may not know that they have to, but they have to ask for it. But also, there is the public security fund exists as well. There's a special item for this reform, the criminal justice reform as well. But in March, in one of the latest sessions of the Council of Public Security, there was an announcement of the creation of 17 million pesos for its infrastructure. But you know how the bureaucracy is to be able to disperse these things. You know that. So I'm just to finish up. CETEC, for work purposes, creates these quadrants. It's a little complicated, but to look at the advances in each one of the 9 areas, so depending on the particular state, and how far they've gone, where they stand in each thing, then we consider whether or not it's advanced firm. And so it depends on the bills that when they ask for the subsidy, there's a practical use to this quadrant. These are the 4 quadrants we created, and this is what we take into account to consider each, to see whether there's advance move forward from each one of the quadrants. My time's running out, and so basically this is what we came to look at, how much progress is made by these different states. In reality, if you look at, there's 2 states that are in the implementation stage, even though throughout the state. There's 9 states that are gradually having it cover the whole state, and there's 8 states that are considered that between now and May or June of 2013 will have gotten to this stage as well. It's good news because of how much they've moved forward. 11 are in the planning stage, and there's 1 state that practically has moved. Nayarit has done absolutely nothing. This is basically what was mentioned by Matthew. It's just a map for you to see the federal criminal procedural code, and this is very important. And this sort of sets forth how where the states stand right now. But the only thing I want to say is most of the states that Matt pointed out that weren't anymore do now, and their Congresses, they have bills for their code. So Nayarit, with the exception of Nayarit, and the federal district, which doesn't have these bills introduced in the respective assembly or Congress. The whole country now does have a bill. It's either in force, or it's partially in force, or at least it's being discussed on the floor of the Congress or the legislative body. And just to finish, before I be butted with his elbow by Octavio, now let's talk about the major challenges. Strength of the body. The federal government has said there has the strength of implementation, and information and evaluation is key, and it has to be well designed. There has to be qualitative evaluation so that there's no concealing of things or things that look fine but really aren't deep down. I think there's a new phase. We have to start working with the operators of justice and the institutions, but also we have to, and there are some, the American Bar Association's doing it, we have to reach out a lot to universities and to private attorneys as well. These are two broad fields where there's a lot of work to do, and I think they're absolutely fundamental so that to complete the cycle. And society has to learn about the reform as well. There has to be a public education effort. And to finish, if we're going to talk about costs, in a question, we'll talk about costs. And that's what that's my presentation. Thank you very much. Gracias, Hugo. Ahora invito a los...
To the mic. We'll start with Carolina Villadiego from the Center of Judicial Studies in the Americas, CEJA.
Well, first of all, I want to thank also the Wilson Center and the Transborder Institute. As Hugo, I believe that speaking Spanish make me more charming, so I will I will switch to Spanish if you allow me. Bueno, en primer lugar, yo quisiera establecer estos...
bring up 3 or 4 fundamental points in my comments here. The first thing I want to say is, generally speaking, Latin America has transformed its procedure, its criminal procedure, over the course of the last decades. In some way, Mexico is one of the last countries to do so. There's still 2 more countries that have not undergone this transformation, but Mexico is one of the last countries to undergo this transformation, which has its advantages and disadvantages. Among the advantages, I would like to highlight first one, and that is that it's clear it can use lessons learned from other experiences and also roadblocks that other countries smacked into when they were trying to transition into this reform, because generally speaking, Latin America has the same legal tradition as the European continent, and to adopt the adversarial system needs a bit of a mixture between the inquisitorial as well as the continental system has to be mixed with it, and there's a lot of challenges that have to face, and this is the two things. I'll mention these later with regard to this, but I also want to mention that with regard to Mexico, with regard to the late implementation, first, so to speak, has disadvantages as well. Among the disadvantages, that they're one of the last countries to implement this kind of a reform, is that what has been seen, there's been a mixture with a need for citizen security or public security, and it's been mentioned quite a bit. The reform was there was a need arose to strengthen criminal investigation to generate better citizen security, while at the beginning of the first reforms and processes in Latin America were based on the need to make a transition to a democracy, and so therefore to generate oversight or control, which is a bit what Laura was mentioning with regard to the institution in which there was no confidence in, mainly the police, and then Matthew made a specific comment about the police. But what I mean by this is that one of the disadvantages that the process in Mexico may have, which has been, Panama has the same thing, is that at a given point in time, it's not only is citizen security and sort of over eclipsing it, but at the same time, there's a need for counter-reform that has emerged. What do I mean by this? It's clear in the Mexican Constitution that they establish crimes that are not subject to release, pretrial. So even though exceptions to preventive detention are established on the books, but these exceptions, pure exceptions, where there's a maximum amount of time that a person can't be held in preventive detention, it was only going to be applied 2 years after 2 years after implementation. What I mean by this is this context is one in which the reform is going on, but at the same time there's counter reform going on. In other words, not having it. But then that's why Chihuahua brought down its preventive detention rate, but also there's some increase at the same time, is what I mean. There's kind of a contradiction. So I want to go to 2 main points here. Even a lot has been mentioned about the Latin American systems and what the changes entails. But one of the core points is that Latin America was and still is in some sectors sustained by the inquisitorial system. There's many characteristics of the inquisitorial system, but I'm just going to mention 2. There are a lot of them, but based on what's been said this morning, two central characteristics of the inquisitorial system is the very bureaucratic. Everything, the practices are very the police is bureaucratic, the prosecutors, judges, everybody's practice is very bureaucratic. It's very highly bureaucratic. And this is clearly seen, we can see this clearly when there's a written court jacket and when there's no, when there's files that are full of so many papers where probably it says that let it be notified that this should be done and that should be done. Everything generates a lot of paper. But the central thing is that the operators of justice were sort of stuck, and they're still stuck in these highly bureaucratic practices where this is of great concern. But in addition to that, there's another element that I would like to stress that's very much like part of the inquisitorial system, even though it's trying to be reformed. It's been reformed in several countries. It's been amended with that. In addition to the highly bureaucratic practices, it's a system that is based as well on secrecy. Secrecy is at the center of it, and so therefore there's a lack of transparency. This is part and parcel of the system, and it's of the inquisitorial system, that is, and therefore it's important to make strides forwards in two essential things. Firstly, we have to make the system more transparent and therefore greater accountability throughout all parts of the system, but also we have to move forward in creating better management practices. And this is very important, is to focus on the methods of investigation and also the work efforts of the prosecutor's office. And so those two elements that I just mentioned, and this is sort of a historical background to this implementation of this reform of our criminal justice service. I want to bring up two things regarding the reform process.
First, what's been mentioned, that there is no information, that it's not public, it's not known just how many cases there are, that is to say publicly. The institutions probably have this information, but it's not information that is shared. It's part of this trend that we had of not having information systems and also of not sharing information. And one of the key lines for the criminal justice reform in Mexico and in Latin America in general, and this has been one of the big struggles, is to make the system more transparent. Transparency has generally been seen just as oral and public trials, and therefore that's one of the key elements. But it's not just oral and public trials, but rather we need to inject transparency into the system, the police, the prosecutor's offices, the judges, everything, forensic medicine, etc. And I think that that is a fundamental issue. But in addition, well, now I see a drawing of a figure showing that I've been hung. Well, there's also a fundamental issue, and this is the second point I wanted to mention, with the prosecutorial authorities, or the whole criminal prosecution apparatus, which is the prosecutor and police. We must recall that in Latin America in general, to a greater or lesser extent, in some countries more than in others, it has moved from police forces in which there's a high level of distrust. Ana Laura mentioned it this morning. There are major challenges of authoritarian regimes in which the police, well, there's major distrust of the police, and therefore the reason why in the criminal justice or the criminal procedure reforms in Latin America, the police have not been given greater autonomy, but rather control over the investigation and control over the complete criminal investigation has been given over to the prosecutors. And this has to do with the level of distrust and the need to control the work of the police much more. This is why we need to generate better models for management and the work between the prosecutorial authorities and the police, greater control over what is done, how it's done, and only in this way are we going to be able to take on the whole question of serious investigations of highly complex crimes in which there's a need for significant control over investigation practices, investigation strategies, what is done, among other things. And so the trust needs to be built between the prosecutors and the police, which is very important. It's not likely that the police are going to be given more autonomy, but rather the work of the police should be made more transparent, so as part of consolidating the investigation. This is what I wanted to share with you. Thank you very much.
Have our last discussant, Robert Ferenek, for the Open Society Justice Initiative.
I too think I'm more charming and illuminating in Spanish, but I'm not going to put that to the test here, especially since I stand between all of you and lunch. It strikes me that there are two phases and distinct skill sets implicated in the processes we're talking about. Thinking about what kind of reform has tended to be, to some degree, unfortunately, in Mexico, but it's tended to be, as it is often the case in many places, a process driven by lawyers in which we imagine a single person going through a track, starting from the beginning and going to the end. And that's important, even if we remember that the oral trials will inevitably resolve very, very small percentages of the cases or crimes. There's an important reflection of values in a ritualized process that we imagine and try to carry out. So that's important. It's important to get it right. But this panel and the challenge of implementation really is about the aggregate. When you put this into systems and you multiply it across 32, 33 jurisdictions, you're really trying to figure out what's happening to the individual when you don't any longer have the time or luxury of actually thinking about the individual in the way you do when you're drafting a code. So the date that's important to me is really not 2016. The date that's important to me is 2026 or some other time in the future when we look back and we say, did we succeed? Did we actually change anything? We rewrote the code. So is this deck chairs being rearranged on the Titanic? Did we change the Titanic to something else? Do we turn around? I mean, what metaphor is up to you to choose, but really we want to know whether we're in a position, whether we're on track to have change that sustains itself and change that we want and that somehow reflects these values that we hope were appropriately debated and consecrated in the constitutional and code reforms. The point of no return is a phrase that's come up a couple of times. It's actually in one of the descriptions of the new RFP for the USAID Rule of Law project. And I share the notion and the value and the desire that we will get to that point. But really the question is, how do you mark that? And in the real world, can you ever reach it? We've talked a lot about counter-reform in the political sense, and these are eminently political processes, right? And one of the things that is so valuable about the panelists is we've had the data, we've had the politics, we've talked about institutional practice, we've gone macro, we've gone micro. So we know that there's a lot here. This is not just a technical exercise. But in counter-reform, so we might have, as occurred in Mexico and other places, a debate simply about, is this a code that's too liberal or garantista? Does it give rise to impunity versus the other side saying that? And we might have counter-reforms in the nature of reformed legislation, right? We might roll back the codes. That could happen. In fact, across Latin America, Carolina talked to us about this wave of reforms throughout the last 2 decades in Latin America, and probably in about a dozen of those countries, there have been significant counter-reforms. And I'll talk a little about those later, but that's not particularly what concerns me, and it's not particularly what concerns me in Mexico. Mexico is somewhat unique in that it's got a 70-year tradition of governmental strength, real capacity to put deep roots in a set of patterns. And as Ana Laura once said to me when I first arrived in Mexico as part of the sort of helpful hints package that I got from many of the people here, I said, we change things in this country to keep them the same. And that's not only in Mexico, but when I was recounting this notion, sort of praising my remarks at the dinner last night among the panelists, as I started to say that phrase, everyone repeated it back to me. And it's quite clear that the possibility that we'll revert back to the norm without changing much at the legislative level is probably the greater challenge. And I think that's where this notion of measurement becomes most important. Measurement is extremely difficult, and indicators are very are imperfect instruments. I had some slides that I was going to try to put on, but maybe we'll just, since I don't see them behind me, and there's only a few minutes left, I'll just talk about 3 topics and try to create the graphic image that was supposed to flash on the screen. One thing Guillermo talked about was prosecutorial efficiency. How good are prosecutors in the new system at resolving cases, at getting them to the next stage, getting them disposed of in some way, either up to the judge or through other means? And I agree. I think one of the strongest sort of natural advantages of the new system is the possibility to dispose of more cases. And of course, the narrative that goes with that is that we will then be able to use our resources on the important ones and take those to the courts. When you see Guillermo's report, you'll see a bunch of boxes. That is the flow chart of how in the old system and the new system prosecutors dealt with this. And the bottom line was roughly 2 times the number or percentage of cases get resolved in the new system as opposed to the old. You can clear 20% at the prosecutorial level in the old system, and it's something like 40 in the new system. We don't know what's in the boxes. That's what we don't know. We don't know in part because there's not a tradition of assessing that. We don't know in part because it's a new system. But it is a deep problem. If you're the prosecutor, you might be, by disposing of these cases, you might be consigning with prejudice a victim of domestic violence to a reconciliation agreement from which there's no return, despite the fact that a spouse may not abide by the terms of the conditions of the agreement to not prosecute. Prosecutorial bail gives a prosecutor so releasing somebody before this case comes to court. I can take somebody into detention. I can then release them. It's not used often, but it is used in some states, particularly Morelos, which is a reform state. That gives me months to decide whether I'm going to take a case to court, and gives me a real important bit of leverage if I want to extort, if I simply want to create a balance of power favorable to me. We don't know. What we do know is fewer cases are getting to the courts. They're being resolved at a lower level. That sounds great, but until we are clear what happens inside those small boxes, we cannot tell whether people are actually taking advantage of the cover of a reform system to do things that are actually pretty much traditional, or maybe even some new forms of moral hazard. So that's boxes. So no sooner does it go up than it goes out. See if we can move on to this. Pretrial detention, just a second point. Again, what seems to be some very good news. 25,000 people avoided this. I think that part is probably true and unassailable. I actually think the story on pretrial detention is particularly important because it's my sense that the logic of the Mexican prosecutorial practice is really reflected more in pretrial detention than any other thing. So the blue... Yes, so the 2 lines, the line going down is actually number of imputados. So it's people we're bringing into the system, and the line going up is number of people being sentenced to more than 3 years in prison. Actually, you have to look at this slide together with the next one. So let me try to. These are yes, this is national. These are reform states.
Los cinco estados.
Right,
Los cinco.
right, okay. So let me show you these 2 slides, because putting them together says something. This is actually, so on the top we see a line ascending about people getting more than 3 years in prison, and a line descending about cases being brought to court. At the same time, we have, looking at pretrial detention, the red is pretrial detention in the non-reform states, and the blue is pretrial detention in the reform states. Guillermo provides various metrics. The point I simply want to make with these 2 things is we don't know. It is true that people have avoided pretrial detention. We do not know whether this is a factor of what seems to be a lower level of just a lower caseload that's coming in the reform states, or we're changing the minds of prosecutors who are not asking for detention, or of judges who are not granting it. There's only one state in which we have very limited evidence based on a small pilot project in which it appears that prosecutors are more or less staying with their same practice of asking for detention, but judges are changing and going from a situation which in the majority of cases they detain to a situation which in the strong majority of cases they now release under supervision. Again, the point here is these are the kinds of subtle things that are very difficult for us to measure from this distance. And if they're not measured at the agency level, it will be very difficult for us to know what's happening. And I'll bring, I think there's one more point I wanted to raise, which is the narrative, the political narrative that we will use to argue against counter-reform is that we're diverting more cases, we're using more resources on the serious cases, we're getting more security. So here is, there's some data that Guillermo puts forward that says there's a significant increase in the number of, I think it was cases in which the sentence was something like 17 years or more. This was Chihuahua data, or, yeah. This is just Chihuahua. But there's a general sense that we're using these prosecutions for more serious crimes. However, if you look at Chihuahua, you see a many-fold increase in intentional homicides between 2003 and 2011, from under 500 to more than 3,000. If you look at the number of cases of indictments, the number has gone down from 300, that's the second line, 300 to 200. And if you look at the number of convictions, it's gone down from about 275 to 127. And yet, the number of long sentences has increased. What is this telling us? Is this the penal code at work? It is not necessarily telling us that we are focusing on the number of long-term sentences, does not tell us that we're actually doing what the narrative says. So just very briefly, those are three very quick points, but they are not intended to critique the study. They are intended to demonstrate the limit of the data we have available. The effort was enormous to get this data, and to say that until we generate that capacity at the most local level, at the level of the agencies operating the system, we're never going to get to the point where we can really answer these questions, and we don't know whether operators steeped in tradition will revert back, because as in very sort of banal terms, the advantages that the old system gives to a prosecutor, quite apart from whether that actually generates any security, but it generates terrific advantages for a prosecutor, the ability to detain sort of automatically. So those incentives remain. The question is, do we have a system that beyond the level of what the code says, actually allows us to measure, supervise, reinforce, hold accountable, and do all those things that ensures that the behavior that we imagine when we draft a code will happen. So there's other small causes for concern that I think are worth. One is the question of backlogs. There are states in where we see a significant percentage of cases. Matt raised the issue about new cases coming into the system under the new system. There are states where there's a significant number of cases that remain in the old system 4 years after the start of implementation, which we've got a minimum of a 4-year period on some of those cases. One other thing that I guess this should tell us. This number, 127 convictions longer out of 3,000, it's a reminder of two things, I guess. One, that to think that the Criminal Procedure Code and the courts as such are going to be the drivers that influence the crime rate is completely absurd. And those of us within the sound of my voice know that. But the debate in Mexico has often been, and we can refer to comments by previous Gobernación secretaries talking about the impunity as if this phenomenon, changing the Criminal Procedure Code, really is what we're talking about. The second thing is obviously the limits, even with a system that has created the undeniable capacity to divert a number of crimes, the limits on judicial capacity to clear cases. And that may be because we've not done enough re-engineering of of the way the prosecutors and the courts work. It may be that there's just actually a limit given the human, the installed capacity. But we may not be seeing a steep rise in those things. And of course, that just brings us back to all the other things that are part of reform. So to close, we shouldn't fool ourselves. We've got a wonderful study. The level of discussion we can now have about where the reform would have been impossible without this effort. It was heroic. It wasn't easy. There's a wealth of information in the state court studies that I recommend to everybody. But we shouldn't fool ourselves that we actually have the answers to all the questions. We have a basis for better questions. I think from the point of view of the sort of agencies here, particularly USAID, I think one area for partnership between the Mexican authorities and the U.S. is precisely on this. We've heard from the first panel, this kind of statistical management, this is not the tradition of Mexican authorities administering systems. So there is room here. CETEC cannot possibly do all of these things over 32 states. There's going to be a need for modeling some. I guess I'd add one point that I didn't hear in any discussions, which is tort law. The reason I mention this is because one of the odd sort of experiences one has in Mexico is that small fender benders become criminal cases. So just one other question is whether there are other aspects of civil law, apart from the diversion within criminal law, that are useful things to think about. And lastly, I said to myself midway through the panel that I was not going to give my opinions on the relative values of experimentation and federalism that we have to, that we experience in the United States with 19,000 police forces. So it may be that the balkanization is a greater problem than the benefit we would get from experimentation if we said to the states, go forth and prosper, and we'll figure out which one of you has done it best. But it does mean that if we have a president who is now talking about a Código Único at the substantive level and the procedural, that the stakes are that much higher. Some states are doing a better job in measuring what they're doing. Some states are doing a far worse job. If everybody's doing the same thing and has the same basis for doing it, then it had better be a good one. Thank you very much.
Thank you very much, Robert. And we'll have about 10 minutes for Q&A. I would like to start with folks in Mexico City. ¿Hay alguna pregunta en México?
Any question coming from Mexico?
First of all, I'm going to take all questions,
Bueno,
and
vamos a
then we'll
escuchar
give some
primero
time
todas
to
las
every
preguntas y
panelist
después
to give the answers.
Vamos a apartar un tiempo para las respuestas.
Sí, buenas. Allá creo que ya son tardes.
Yes, good
Yo nada más
afternoon.
quería, felicitar desde luego
I would just like
a
to
todos.
congratulate
y a,
everyone
Carolina Villadiego también.
and Carolina
Fue
Villadiego.
una mesa súper interesante.
It was an extremely
El
interesting
análisis y las
panel,
preguntas que nos deja
and the
Robert
analysis
al
and the
final
questions that Robert
son
leaves us with at the
interesantísimos.
end are extremely interesting.
Pero yo nada más quería hacer una precisión en cuanto a lo
I
que dijo
just wanted to say something about what
Matthew Ingram.
Matthew Ingram said.
Mencionó que
He
en
mentioned
Nuevo León
that in
los
Nuevo
jueces,
León,
tienen cachuchas, dos cachuchas, y
the
parece
judges
entender que
are hooded or
conocían
faceless,
de los dos sistemas.
and
Y eso,
that they
con todo respeto, pues creo que
knew
es
about
equivocado.
both systems. And with all due respect, that's a
En Nuevo León,
mistake.
Existen los
In
jueces
Nuevo
están
León,
especializados en
there
el
are
sistema
judges who
acusatorio
are
y solo
specialized in the
conocen de los
accusatory system, and
delitos
they only take cognizance of those
que entran
offenses
ahorita, para los cuales se ha diseñado en esta primera fase
for
el
which
sistema acusatorio.
the accusatory
Nunca va a
system
conocer
has
un
been
juez
designed for this
control del
first
sistema
stage. There will
acusatorio,
not be any
de casos del
judge,
sistema, sí,
due process
efectivamente,
judge
sistemas,
in the accusatory system
llamémosle tradicional,
who will be
o el
hearing
mixto,
what
que
you
fue
could
lo
call
que
a
la reforma
traditional
del 2004.
case or the
Nada más
mixed
quería hacer
or in a
esa
mixed
precisión. De hecho,
procedure
también los
as that
defensores
stemming
públicos
from the
están
2004 reform.
específicamente
Indeed, the public
dedicados,
defenders are
especializados al sistema
exclusively
acusatorio, igual que los
devoted
fiscales
to
y
and dedicated to
que algunos
the
investigadores.
accusatory system, likewise
Entonces, yo
prosecutors
quería
and some
hacer esa
investigators. So I
precisión porque
wanted to
no
note
es
that
correcto
because it is
el
not
hecho de que se diga que en Nuevo León
correct to say that in
los
Nuevo León,
jueces o el sistema
the judges
es
or the
mixto, o el
system
código,
is mixed.
pero ni siquiera el código procesal, la verdad es un código
Well, not
procesal,
even the procedural
creo que de
code.
tercera, cuarta generación,
I think it's third or
tampoco es de
fourth
tipo mixto,
generation
es
procedural code. It is
bastante
not mixed either in
acusatorio,
nature. It is very much accusatory, I believe.
y quería hacer esa precisión nada más.
And I
Muchas
just
gracias.
wanted to
Do we have
specify
any
that.
question from Twitter?
¿Hay preguntas de Twitter?
Okay, so take
Hay otra
two.
pregunta de México.
There's another question
I'm
from
sorry,
Mexico.
we're gonna take a couple of questions here, and if we have time, we'll go back to Mexico City.
Gracias. Para Hugo Concha, si nos puedes compartir los datos de costos y
If you could
presupuestos.
tell us the cost and budget data, and Matt and Guillermo, do you find a common factors between those states that are lagging most in the reform?
Carlos Jauregui, de la Sociedad Civil de Nuevo León y
Carlos Jauregui,
de Seguridad Pública dentro de unos meses en la administración de Rodrigo Medina.
Secretary of Public Security in a few months in the administration of Rodrigo Medina. I'm from Nuevo León. The issue is, how can we create political will for this to happen in the country with new governors, new officials, new presidents, and so on? So I would like to hear comments from the panelists. We detect two main problems in Nuevo León. One is the problem of political will to do things that are going to undermine your own power. In other words, the governors lose power when they give power to the prosecutors. And the other is all the holy cows that we have in the universities and the attorneys who drive Mercedes-Benzes. And with this, they're going to stop receiving such large incomes. Muchas gracias. Ahora otra pregunta del DF. Y una última pregunta aquí. My name is Alonso Gonzalez. I work with an organization financed by U.S. assistance. There's one issue that's been discussed all morning. I believe firmly that if we don't talk about amparo, then the whole discussion will be futile. The whole exercise of measurement and transforming the procedural systems in Mexico cannot leave aside the institution of amparo, which for many reasons became the fundamental instrument used by defense counsel to resolve criminal justice issues, and which has serious incompatibilities with the accusatory system. I'm not saying that it's bad. They're just procedural regimes that were thought up for different circumstances, and without adjusting the two systems, everything that one might try to do with single or federalized codes will prove useless. So I would suggest to all that are there that we need to do a lot about amparo, or else all of this will go nowhere.
Mi nombre es Marco Carrillo, soy el director de Seguridad Pública en Mexicali. Y bueno, sobre todo para Hugo Concha, él habla de los dos procesos de la reforma de seguridad y también de la parte de la reforma de justicia. Ya en la práctica, desafortunadamente,
In practice,
son dos cosas
unfortunately,
completamente diferentes. A la policía no se le toma en cuenta, independientemente que somos el primer
the police are not taken into account, even though we're the first responders. And there will be talk of the experience in Mexicali, but these are very important, and the whole classification that you've talked about, from planning to infrastructure and equipment. The whole effort is on training, and this is training that is deficient, not from the viewpoint of the police themselves. Well, I would thanks to Ernesto Canales and others, the police are now being invited to the forums. The police must also be immersed in this process. There cannot be a distancing between the two reforms, because clearly, well, the police need more training, more formal studies, among many other things. So the police are not immersed in this process. There was talk of this being an integral or comprehensive process that is fundamental, and without that, and without coordination, this isn't going to work. So the police need to be there. President Peña Nieto has to take this into account if the reform is to work.
So we have 6 questions. One about the jueces in Nuevo León with 2 different capacities, budgets and costs of the system, the factor común between the estados rezagados, the amparo factor, and the security and justice, 2 different initiatives in the same reform. So I'll ask each of the participants to address 2 of the questions, and I'll ask them to be as brief as possible.
Muy bien. Bien, muy buenas tardes, pues muy fructífero.
Good afternoon, very productive. I'm taking notes of all the comments. The general report, as I was mentioning before, there's 5 state reports, and they're very much of a qualitative nature. What we're intending with a report is to compare them and to come up with an average. And with state average, it's not always accurate to reflect reality, but the state reports even are region by region within a state, or those that do have a reform. And so there's some clarifications, of course, about this situation, which, for example, with regard to domestic violence, domestic violence, because that doesn't really apply in this study, and also monitoring, electronic monitoring, because we propose, and Cejas mentioned the judicial control of the reparation judges, except in Oaxaca, and the other states are 80% of these reparation agreements are not reported. And so in Chihuahua, as a matter of fact, we quote these figures, and there is an inability to better investigate these cases as well. And the chart that sums it all up is in English. This only has 2011 data, but it shows the installed capacity of Chihuahua. It doesn't have enough to sentence 200 people more. In other words, what I'm saying is it's the demand for services vis-a-vis installed capacity is just not there. They can't cope, is what I'm saying. So this is there's been achievements in this, but I just wanted to point this out, and I'm very glad about this study of support for the justice system from USAID, that is. And there's been, even though haven't been a lot of achievements, there's been some, and I'd like to the 11 researchers that have taken part, and those that are working in Baja California and Durango, who we've received generous support from USAID for this project. With regard to the lagging states, the states lagging behind, this is what happened in the western part of the country. I live in Jalisco, and unfortunately Jalisco and Nayarit and Colima haven't been making strides forward, and also Aguascalientes in 1995 was the paradigm, the World Bank of this, and the European countries were waiting there to move for the reform, and it didn't happen. And so this is things were promising, but nothing happened. So what we have to do, not only in criminal justice, there has to be institutional strengthening, is urgent throughout the country, and in all that. It's very, we call it fulanizado. It depends on any Tom, Dick, or Harry who's in charge. It depends on, instead of there being continuity. And a lot of times people aren't familiar with the reforms. That's why they're not. So to strengthen these reforms, this is important. Amparo, as far as the Amparo procedure, I concur with my colleagues, but I want to take time away from them. But as far as the attorneys, this is absolutely important, and we have to analyze the report, and the proposing attorneys are the ones that criticize the system, but they don't provide the information. And if we don't deal with this sector of the attorneys, it's got to be coordinated with the reforms. There's some in Baja California. There's some initiatives. And they say, why should we negotiate about something as intangible as justice, and we're moving to oral trials? What about the next year in Baja California? It's going to be. Let's see how it goes. And then there's a counter reform blocking it, though.
Sí, bueno, voy a contestar la pregunta.
Okay, I'm going to answer the question about the two hats in Nuevo León, and perhaps part of the questions of the Miguel Basañez question I'll answer. It was not the best way of expressing it, but it wasn't my intention to just say that there's just one judge that in the morning is in charge of cases in the inquisitorial systems, and takes his hat off and puts off the reform system, the new adversarial system, and puts on his new hat and does it that way. And there's a type of schizophrenia, legal schizophrenia going on. That's not what I meant when I said mixed systems. I would be the best comparative law professor that there's ever been, if that was what was going on. But what I meant is that all transitions and with reforms, there's always a overlapping of the two systems. And for those who are not familiar with the way that the reform is being implemented in Mexico, most of the states have selected implementation by district. It's one state, Nuevo León, and perhaps there's others that are doing it, have opted for an entirely different path, which is just by crime to do it subject matter implementation. Implementación por tipos de delito. We could debate which is the best strategy for implementation, but it seems to me that both the comparative analysis between countries, looking at the experiences in the Latin American countries, such as as well as the state's experiences in Mexico, shows that the best strategy to follow is in implementation by district, gradual territorial implementation. And it seems to me that the crux of this is that there's less overlapping or there's greater clarity about when one system, the traditional, is over, and the new system is effective and in effect enforced when there's district by district implementation. This is a clarification, but thank you for the clarification. Now, with regard to the question from Miguel Basañez, I think this is one of the pending big questions. That is, what are the origins, the sources of the reform? Why some states are moving forward quicker than others? Hugo mentions the political will. As a political scientist, I wonder, political will, Hugo mentioned, and as a political scientist, compartimos esa preocupación, cómo operativizar la voluntad política, cómo se mide, qué significa la voluntad política. ¿Es por ideología? ¿Son los incentivos materiales que se generan con la competencia electoral? ¿Es por liderazgo judicial? ¿Es por presiones de la sociedad civil? ¿Qué es lo que crea la voluntad política? Y es una pregunta abierta y muy buena pregunta, por cierto. Just quickly, with regard to the cost question. Without question, this is one of the major concerns and issues. As a matter of fact, one of the main stakeholders have been Marcelo. In all the forums, he always talked about the money side of it. I think it's the reform, and one of its transitory provisions stipulates that there has to be budget for all the states and federation, that there has to be allocated for the criminal justice system reform. But that's all it says, that there has to be budget allocated. So what's being actually done? There's been studies that have conducted. Some are more serious than others. I'm familiar with the one that was just ACETEC, just about cost benefit of implementation that's been released. It's broader. There's a very preliminary study that the Supreme Court of Justice has prepared about how much this will involve and what does it mean. one of the things, at least the ASATEC study, is important to distinguish between what the investment cost is of the transformation and the cost of maintenance of the maintaining that is the new system. And so the cost of investment is additional extra money because there's a lot of changes, particularly in infrastructure and facilities. And this will generate quite a great deal of cost, but also it depends on each state and each institution, because there hasn't been much planning of the growth of the institutions in general in the criminal justice sector, who don't even really have much money. So once a proper management is put into place and that they're organized under the new standards for the institutions, some of them, what they've decided is they think that they're going to even save money. It seems if the issue of saturation and or overcrowding in prisons will have savings. There are going to be savings there, for example, in the prison system. And what do we know? We know that Chihuahua formally says that more than 300 million pesos have been spent by Chihuahua. There's an official, that's not official. That there's a lot more that was spent on that because they received a lot of direct technical assistance. What is it's estimated that among the states, depending on the size and the circumstance of each one, it will be between 300 and 900 million pesos, particularly with regards to the investment in the change. This depends on each stage. The court determined that for the federal judiciary in the country and throughout the country, it's disputable that they said there was going to, with 600 billion, the highest of 12 billion, from 6 to 12 billion pesos. So this we have to work harder on this stuff. And just quickly, to answer another question, with regard to the police that Marco had asked, I think there's a fine line. We've tried to not contaminate the criminal justice reform. Is that security has sort of that the police issue is what sort of mixes in, and so the ASATEC study said that we are going to deal with this when it comes to investigatory police. That's all, because because the rest of law enforcement it doesn't have anything to do with the criminal, but it does. You have to work on training and a lot of things. It really does. But I think this is the fine line that has to be, so things have to be defined more clearly because of this. Gracias a todos. Y con esto se concluye este panel y vamos a pedirles que vayan a almorzar.
Come back as soon as possible to start the keynote addresses. Thank you very much.